Welcome to video presentation number 10. This video will discuss accomplice liability. Up till now we have been discussing criminal liability in terms of a single perpetrator. As you will see through this video, the law seeks to punish those who aid, assist, or encourage another to commit a crime. Let's begin. At common law, parties were defined in very different ways than they are generally today. There was first the principal in the first degree. That was the person who actually committed the crime. In addition, there was the principal in the second degree. This was a person who aided the principal in the first degree and is present or was constructively present, and we'll see how this works in a few minutes. And next, there was an accessory before the fact. This was a person who aids, encourages, or counsels with the requisite intent, but is not present. They were not either constructively present or present at the exact scene of the crime. So let's look at a couple of examples of how this might work. So we have our guy with the sunglasses here, the gun in his hand, and he says to the fellow with the baseball cap, "Here's a gun to use to kill my professor. I'll watch the door." The guy takes the gun, shoots the professor. "I just shot the professor dead." Professor falls over dead. The person with the gun who shot the professor with the baseball hat is what would be considered the principal in the first degree. The person that was standing watch at the door and who gave him the gun both becomes the principal in the second degree. He both aids and encourages by giving him the gun. In addition, he aids and encourages by watching the door. As we will see, both of these actors are guilty of murder. The law makes both the principal in the first degree and the principal in the second degree guilty of the very same offense. Another example, again, our fellow with the sunglasses with the gun says, "Here's a gun to use to kill my professor," but also then says, "I'm leaving now. I don't want to be here when you do it." He gives the guy with the baseball hat the gun. Professor shows up. Bang, bang, the gun goes off. "I just shot the professor dead." Professor falls over dead. Again, the person with the gun is the principal in the first degree. They are the actual perpetrator of the crime. The person who gave him the gun and left the scene, so he's no longer present, he's not constructively present by, let's say, being outside in the getaway car or being at the door, he has left completely, is an accessory before the fact. He was known as an accessory before the fact, and he too is guilty of murder, just like the principal in the second degree was. And here he's guilty of murder because by giving the principal in the first degree the gun, he has aided and encouraged the principal in the first degree to commit the crime. Now, in reality today, the principal in the first degree is often referred to as the principal. The principal in the second degree and the accessory before the fact are generally referred to as accomplices. That's why this is referred to as accomplice liability. So there is the principal, and then there are the accomplices, and they are the ones who aid, encourage, and assist the principal in committing the crime. So, at common law, accomplice liability is derivative. That is, it flows from the principal. So the accomplice's liability, their criminal fault here, flows from the principal. However, today, the principal need not be convicted. At common law, there were some very peculiar procedural rules that required that in order to convict an accomplice, you had to convict the principal. And if the principal could not be convicted, you could not convict an accomplice, obviously creating an incentive on the parts of the accomplice to do away with the principal or to inhibit the conviction of the principal. This is not the case today. Even if the principal is not caught, cannot be convicted, the accomplices can be convicted. What is required is the prosecution must prove that there was a principal who committed the crime and the accomplice aided with the requisite mens rea. So that is that they have to show that somebody out there committed the crime and that the accomplices aided in this. Now, let's look at the elements of accomplice liability. The first element is with the intent to aid, encourage, and counsel another. So you have to have this intent. This is the first of two what will be intents in accomplice liability. One does aid, encourage, and counsel. That is, you have to provide aid, encouragement, and counsel. You actually have to do something. It is not enough that you think that you want to aid, but you actually have to aid in order to be guilty. There has to be some conduct involved, and it has to be obviously of another to commit a crime, so it has to be focused on a specific crime. So you have to aid, encourage, and counsel towards the commission of a specific crime. And finally, with the intent that that person commit the crime. So here we have the second intent coming forward. So there has to be an intent to aid and an intent that the person commit the crime. Making accomplice liability, obviously, in essence, a specific intent crime, because there has to be the intent to aid, which is the conduct of accomplice liability, and there has to be the intent that the person commit the crime. Now, so let's explore this. So again, our fellow with the gun with the sunglasses and the perpetrator with the baseball hat. The fellow with the gun is thinking, I intend for you to use this gun, and I intend for you to kill my professor. So the two intents, intent to use the gun, which is the intent to aid, and the intent that the perpetrator commit the crime. Here's a gun to use to kill my professor. Gives it to the guy with the baseball hat, shoots the professor. I just shot the professor dead, he says. Professor falls over dead. Again, we have the principal, who is the perpetrator of the offense here, and we have now the accomplice, who has the intent to aid and actually did aid by giving him the gun, and has the intent that the principal commit the crime. Both are guilty of murder, as we see it playing out. Now, an accomplice is responsible for the crimes that he aids. So whatever crimes he has the intent to aid, and does aid, he is responsible for and can be prosecuted just as if he committed the crime himself. In addition, though, the accomplice is may be found guilty for crimes committed by the principal in the course of committing the contemplated crime, so other crimes that the principal may commit, as long as those crimes were the natural and probable consequences of the crime aided and abetted. And you'll see this, we'll talk about this when we talk about the cases, but it extends out the accomplice's liability to crimes that are the natural and probable consequence of the crime aided and abetted. So again, let's take a look at our two fellows here. The one with the sunglasses with the gun, the one with the hat who's going to do the shooting eventually, and I intend for you to use this gun, and I intend for you to kill my professor. This is what the guy with the sunglasses is thinking. And he says, here's a gun to use to kill my professor. The guy with the baseball hat takes the gun, I just shot the professor dead. But in addition, he indicates, I killed the security guard when I had to break into the building. So now the perpetrator, in addition to just shooting the professor, which was what the guy with the sunglasses had intended, has committed two other crimes. He shot and killed the security guard, and he broke into the building. As a result of this, you have the principal, which has done these crimes. You, in addition, have the accomplice. But now, based on the natural and probable consequences doctrine, both are guilty of two murders and a burglary. The murder of the professor, which was what the accomplice intended, But accomplice liability at common law extends beyond that. This is where the natural and probable consequence doctrine comes into play. If the breaking into the building and shooting the security guard are found to be a natural and probable consequence of the crime of shooting the professor, the principal and the accomplice will both be guilty of these two crimes. Let's take a look at some other parameters of accomplice liability. An accomplice can withdraw from commission of the crime. The accomplice may withdraw before the crime has been committed, but the accomplice must communicate the withdrawal to the principal and make bona fide efforts to neutralize the effect of the prior assistance. Generally, this would be removing the encouragement, takes the gun back, notifies the authority. So again here, I intend for you to use this gun, I intend for you to kill my professor. He said, here's a gun to use to kill my professor. One day later, the accomplice shows back up before the principal has done anything with the gun and says, I've changed my mind, it is wrong to kill the professor. He gave me an A, give me back my gun. So the principal, okay, gives him back the gun. Now, 2 days later, the principal gets a different gun and kills the professor. Well, in this instance, the principal is guilty of murder, but the accomplice is not guilty because the accomplice has withdrawn the aid that the accomplice provided the principal before the crime has been committed. Now let's look at some other pieces here. This is now under the Model Penal Code. The Model Penal Code essentially does the same thing, but goes about it in a slightly different way. So under the Model Penal Code, a person is guilty of an offense if he commits it by his own conduct. At common law, this would be obviously the principal, or by the conduct of another for which he is legally accountable. And under the Model Penal Code, it sets up essentially two situations where one is legally accountable for the conduct of another, thereby making them liable for offenses committed by another. And this will occur in two situations. One, where the actual perpetrator is an innocent agent, and the second, where they are an accomplice. The innocent agent essentially is where the perpetrator does the conduct but does not have the culpability to commit the offense. That is, they do something that is a criminal offense, but because for various reasons they don't have the culpability to do so, but now the one who has sought to have them do it, who's using the innocent agent, does have the culpability but wouldn't have the conduct. So the conduct of the innocent agent is attributed to one who would be now the actual perpetrator. And accomplice liability works very similar to accomplice liability at common law. So again, under the Model Penal Code, to be an accomplice, you must engage in conduct, soliciting, that is seeking another to commit a crime, aiding, agreeing to aid, so even I will help you in the future do this crime. I agree that I will be the lookout, or attempting to aid. And this is different. At common law, one attempting to aid would not be an accomplice because they wouldn't have actually aided. Under the Model Penal Code, if one attempts to aid but doesn't actually accomplish the aiding, they can be found to be an accomplice. And they have to have the culpability of with the purpose of promoting and facilitating the offense. It has to be their conscious object to promote and facilitate the offense. One final little Model Penal Code twist. When there is a result element needed for the crime that is going to be committed essentially by the principal, the one aiding needs to act with the kind of culpability required for the underlying offense, for the result element of the underlying offense. And in class we'll talk about this a bit more. So, in addition, the Model Penal Code rejects the natural and probable consequences doctrine. One is only guilty as an accomplice for those offenses that they seek to facilitate and promote, that they have the purpose to promote. It has to be their conscious object to promote them. And if the principal goes ahead and does other things, the accomplice is not liable for them. The Model Penal Code does permit the accomplice to withdraw. One is not an accomplice if they terminate their participation before the crime has been committed, so that's the first thing they must do, and he neutralizes his assistance, gives warning to the police, or in some other way attempts to prevent the crime. Fairly similar to the common law. Finally, like the common law today, the Model Penal Code creates liability for the perpetrator in relation to, for the accomplice in relation to the perpetrator, fairly similarly. An accomplice may be convicted upon proof that a crime has been committed, that is, that a principal committed a crime, and that he is an accomplice, regardless of whether the perpetrator has been convicted. And in addition, the accomplice may be convicted of a greater offense than the perpetrator if the accomplice had the culpability for that offense. So what the law looks to is, was there a perpetrator? Was there a principal that committed the crime? Even if the principal hasn't been caught, even if the principal cannot be identified. And finally then, it looks to see what the culpability is for the accomplice to determine what offense the accomplice will be guilty of. And again, we will talk about this in class. That concludes this video session on accomplice liability. As always, you need to go to the TWEN site and fill out the assessment for this video presentation. Thank you.